A very good afternoon to all of you present in this webinar. I am Anubhav Yadav, your host for today's webinar, and I welcome you all to this wonderful session, webinar session, which is based on recent amendments in the Arbitration and Conciliation Act 1996. So, and India's way forward, and this is the important part, I guess. So, before reading out Sir's profile, today we have Advocate Tariq Khan, sir. So, before reading out Sir's profile, I would like to thank Tariq, sir, on the behalf of every law student out there. I mean, thank you so much, sir, for sharing such a valuable content on LinkedIn, not on a daily basis, but yeah, whenever you get your time. So thank you so much, sir. Whether it is internship opportunity, whether it is related to career guidance or anything. So thank you so much, sir.
Thank you. Thank
So
you so much.
now I'll begin reading Sir's profile. So Sir is enlisted in the Forbes Legal Power List 2020-2021 as one of the top individual lawyers. He is the youngest Business World Legal 40 under 40 2020. He has been featured in Fortune 500 magazine, special issue 2017-18 for authoring the bestseller book On the Rise, published by Universal Law Publishing and imprint of LexisNexis. He is recognized as an arbitration expert by SCC Online and qualified to the conference round of Judge Advocate General Indian Army. He is skilled in international and domestic arbitrations, MSME disputes, writs, commercial employment, and insolvency and bankruptcy laws. He has represented some of the biggest global players in various disputes, including construction, supply, joint venture, oil and gas, infrastructure, and renewable energy space. Also, he has represented leading domestic players in high-stake project disputes involving issues related to defective works, breach of contract, loss of profits, liquidated damages, prolongation, escalation, delay, indemnities, and illegal termination of contract. He handled arbitration under SIAC, which is Singapore International Arbitration Center rules, ICC, that is International Chamber of Commerce rules, DIAC, which is Delhi International Arbitration Center rules, ICA, that is Indian Council of Arbitration rules, and many more. He is experienced in handling arbitration related litigation like appointment of arbitrators, injunctions, interim reliefs, removal and substitution of arbitrators, challenging the arbitral awards, enforcement of awards, etc. in various courts of India. He has been frequently invited to speak in various law conferences and events by domestic bar associations, law schools, alternative dispute resolution centers, and amongst other organizations. He has been teaching an arbitration the law as a guest faculty for the past 6 years in some of the prominent schools, law schools of India. He has more than 50 publications to his credit in various journals, magazine, and popular legal news portals. So with this very long, we can say, introduction of yours, we are really expecting a very valuable session today. So with this, one more thing I would like to request all our attendees today to switch off their mics and videos off so that we have little disturbance during the session. So with this, over to you, sir.
Thank you so much for such a lovely introduction. And I hope I'm audible, which is,
Yes,
all the
yes.
we have been starting by saying, can you hear me? This is the most popular dialogue I've heard of all the speakers doing webinars. But thank you everyone for coming here and being present this afternoon. And these are tough times. I hope everybody is keeping safe and taking good care of yourself. This is an excellent initiative which has been taken by Vidhi Parivartan, and I am really glad that they have given me this opportunity. Today, I'll be discussing with you. I would like to keep it an interactive session, but I've been told that first I have to speak for probably it's a 1 hour session, and I'll be speaking first, and then probably I can take up questions that you may have. So, without wasting any time, I'd like to start with the history, a brief history of the arbitration in India, because those developments that have taken from time to time, the important ones, They are very relevant for today's discussion because amendments happened for a reason, and I will be covering in my lecture today every important development that has taken place in the Indian arbitration jurisprudence. So I would like to start by telling you that arbitration law in India, if I ask anybody, a lot of people will tell me that 1996 Act was the first act of India. Some of you may say that the 1940 Act was the first act in India on arbitration. But I would like to tell you that a lot of people do not know that arbitration law was enacted in India as early as 1772. There was a Bengal regulation during the British rule in India. But at that time, arbitration, of course, did not gain popularity. The course of arbitration flourished in India uh, in the end of the 19th century. Now, at that time, a lot of people may not even have heard of arbitration, and arbitration has in fact gained popularity in the past 10 years in India. But the proper act of 1899 was the first act which came in arbitration in India. And this was the first time arbitration in India was recognized as a mode of dispute resolution for resolving disputes between the parties. However, it was confined only to three presidency states, three presidency towns rather, namely Madras, Bombay, and Calcutta. So the Act of 1899 was the first act in which a proper law of arbitration was recognized in India. Thereafter, when CPC, which is the Code of Civil Procedure, it was enacted in 1908, Section 89 of CPC, as well as there was a second schedule added to CPC, which was dedicated completely to arbitration. So now we had 1899 Act, we had CPC Section 89 and CPC Schedule 2. These were all dedicated to arbitration law in India, and they were extended even to different regions where the Act of 1899 had not extended. Because like I told you, the Act of 1899 was extending only to three presidency towns, Madras, Bombay, and Calcutta. That's it. Now, because the 1899 Act and the CPC provisions were not doing any good to arbitration in India, and they were technical and they were not expedient. They were not expeditiously resolving disputes between the parties. Therefore, there was a need felt to bring a proper legislation which will resolve the issues expeditiously and will try to make it less technical. Because the whole idea of arbitration at the end of the day is to make it flexible for parties, and party autonomy should supersede everything else. And it should be very convenient, it should be less technical, and it should be less expensive than litigation. I will not say cheap. So the Act of 1889 and the CPC Section 89 and Schedule 2 of CPC, all of them were repealed by a subsequent act, the proper Act of 1940. So if you may read too many books, you will see this has been a very controversial act, the Act of 1940. This was a proper legislation, Arbitration Act 1940 in India, and it repealed all the other previous law provisions which were dealing with arbitration, namely the CPC Schedule 2, Section 89 of CPC, and the Act of 1899. All of these were repealed and the new act came into existence, namely Act of 1940. Now, this Act of 1940, it was essentially a reflection of the English Arbitration Act of 1934. And it was a comprehensive legislation on the subject of arbitration. There was only one issue with that it had no provision to deal with the foreign awards. Now, at that relevant time, it was dealing only dedicated completely to the domestic awards. And because it had nothing to deal with foreign awards, there was a major issue. Now, the Act of 1940, apart from this issue of not dealing with the foreign awards, the functioning was far from satisfactory. And I would like to tell you a very interesting judgment in the case of Guru Nanak Foundation versus Ratan Singh by Justice D.A. Desai. This was in the year 1981, which is almost 41 years later after the enactment of this act. I think he succinctly, uh, highlighted the poor functioning of the act, and very boldly, I must say, the words were used. And I would like to quote him. I would like to borrow those golden words. Interminable, time-consuming, complex, and expensive court procedures impelled jurists to search for an alternative forum, less formal, more effective, and speedy resolution of disputes, avoiding procedural claptrap, and this led them to Arbitration Act of 1940. So this he gave the reasoning why Arbitration Act 1940 came. Now let's see what he sees later. He says later. However, the way in which the proceedings under the Act of 1940 are concluded and conducted, and without exception, challenged in the courts of law, has made lawyers laugh and legal philosophers weep. Experience shows and law reports bear ample testimony that the proceedings under the Act have become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the unwary. Informal forum chosen by the parties for expeditious disposal of their disputes has, by the decisions of the court, been clothed by the legalese of unforeseeable complexity. Now, the way he has put it, it shows how poorly the Act of 1940 was functioning. It was very technical, very costly, and was going against the spirit of arbitration. So what we have understood from such judgments is that the Act of 1940 attracted severe criticism and adverse remarks from the courts of law. However, no amendments were brought to improve the functioning or the working of the Act of 1940. Because generally what we have seen is that amendments are introduced to cure the defects which are there in the principal act. Now, today I'll be discussing about the Act of 1996, which of course came much after the 1940 Act, because after the economic liberalization in the year 1991, the Indian government realized that it needs to take steps to attract foreign investments. And the investors, of course, would require a comfortable environment, and ease of doing business would be relevant. So therefore, Arbitration Act 1996 was brought in, and the Act of 1940 was repealed. Interestingly, the Act of 1996 was based on the UNCITRAL Model Law on International Commercial Arbitration 1985, and it covered both domestic as well as international arbitration. So now, if you remember, the 1940 Act did not have any provisions for the foreign awards, whereas the Act of 1996, it dealt in two parts. Part one was dedicated to domestic arbitrations, and part two solely dedicated to the foreign awards. Now, the main reason for introducing the Act of 1996 was to curb the delays in arbitration which were taking place in the 1940 under the 1940 Act. Because arbitration, the purpose is to resolve disputes speedily, expeditiously. However, it was not happening, and therefore the 1996 Act was brought in. Here I'd like to pause for a moment and tell you that Indian government at that relevant time in 90s also emphasized on the importance of BITs, because they realized that BITs are the route for attracting investment, because the investors feel very safe when they're investing money in a country through a BIT. So that was one very important reason, but that's not the discussion for today. So I would now like to come to the important developments in the 1996 Act, because that is the Act which as it stands today, and it has been amended on three different occasions, which I will be discussing subsequently. Now, the Act of 1996, which is the Arbitration and Conciliation Act 1996, which is the current act governing arbitration in India. So two important developments took place before 2015. I'll only be discussing two judgments today. The one judgment is of Bhatia International versus Bulk Trading. Now, this was a judgment in 2002, which basically was very controversial, and which was criticized severely internationally as well as domestically. It was criticized for the reason that the court held in this judgment that Part 1 of the Arbitration Act 1996, like I told you, Part 1 deals with domestic arbitrations. So the court said that Part 1 will apply to Part 2 also. Now, Part 2 is the part of the Arbitration Act which deals with foreign awards. So when the arbitrations are seated outside India, the Indian courts are not supposed to interfere. However, this judgment gave that right to the courts that you can in fact interfere, and Part 1, which deals with domestic arbitrations, will apply to Part 2 also. So this was a very controversial judgment in arbitration. Thereafter, another judgment came in 2008, that is 6 years after Bhatia International Judgment. This was Venture Global, and Venture Global also took the same view, which was on the same lines, and this also was very widely criticized for adopting a regressive approach in arbitration because these were not pro-arbitration stance, since arbitration is all about minimum judicial intervention, whereas these judgments in fact encouraged judicial interference in arbitration by letting Part 1 being applicable to Part 2. This controversy remained for 10 years, and 10 years later, because if you recall, in 2002, Bhatia judgment came. So in 2012, this error was rectified, I must say, by a very important judgment and a landmark decision of the Supreme Court in the case of Bharat Aluminium versus Kaisar Aluminium. This judgment, as we call it, it's called Balco. Balco judgment, if you must have heard of it a lot of times. And Balco, in fact, reversed the position and rectified the error which was caused by Bhatia International. So Balco said that Part 1 of the Act will not apply to Part 2, which means that the provisions of Part 1 will not be applicable to Part 2. Therefore, this judgment reduced the judicial intervention, that Indian judiciary cannot interfere in the foreign awards and foreign seated arbitration. Now, there were other issues apart from these judgments, which I have told you in the functioning of the 1996 Act. There were some important issues due to which amendment was required. And like I told you, the amendments are brought in to cure the defects in the Principal Act, in the functioning of the Act, or to give clarity to it. So despite the best efforts of the Indian legislature to make India a robust hub of arbitration, the 1996 Act still suffered from various problems, including high cost and too much intervention of courts. So you remember the reason why 1996 Act was brought in and why 1940 Act was repealed was that there should not be delay in arbitration cases. But it was not serving the purpose, and there was honestly delay happening. Therefore, this was one of the reasons why amendments were discussed. But apart from this problem of delay, the other problem was some major issue was the automatic stay. Now, what was the automatic stay? The automatic stay was that when a person wins an arbitration, who's the decree holder, and if he wants to enforce the award or execute the award, the losing party will file a challenge under Section 34 of the Indian Arbitration Act to resist the arbitration award and to challenge the arbitration award for setting it aside. Then the moment the losing party files this Section 34, the challenge to the award, the execution of the arbitral award automatically gets stayed. Now, just focus for a second. If you are winning an arbitration after so many years and then you cannot get the money because the person has challenged it in the court of law, and you cannot enforce your award until the decision comes in the challenge. So until the court decides whether the arbitration awards will be set aside or not, you are deprived of the fruits of the award. You will not get the money. So that was a major issue with the 1996 Act, and I think it was unheard of. In no other country, probably you would have heard or you would find something like this. So that was one of the major reasons why people started losing faith in arbitration, and they did not like this idea that even after winning an arbitration, we cannot get the money after all, which is required. Other reason was that there was no time limit or time period for making an award in an arbitration. So this would eventually make arbitration very costly, and people would wait for years and arbitrators would charge them per hearing. So another issue, like I just pointed, was that arbitrators were charging significant fees, and per hearing they were charging, and the matter was going on forever, for 10 years, 15 years, due to which parties would just not be interested. So, due to these reasons, the Ministry of Law and Justice invited suggestions from eminent practitioners, from law students, legal experts of the country regarding the functioning of 1996 Act and how it can be improved. And therefore, under the chairmanship of Justice A.P. Shah, the Law Commission report finally came up with certain suggestions to amend the Act of 1996, and certain important and major amendments were made, which in fact improved the functioning of the arbitration in India. The first and foremost important amendment of 2015 Act was regarding the Section 2.2 was added, which said that provisions of Section 9, 27 and 3731A shall be applicable even to Part 2 of arbitration. Now this amendment did strike a balance between Bhatia judgment and Balco judgment. Bhatia said Part 1 applicable to Part 2. Balco said the provisions of Part 1 will not be applicable to Part 2. Now this amendment of Section 2.2, it said that only 3 provisions of Part 1 will be applicable to Part 2. Now what are these provisions? The one is Section 9, which is interim relief by the court, which means that you can resort to a Section 9 in case of a foreign-seated arbitration. The second is Section 27, which is the court's assistance in taking evidence. And the third one is 3731A, which is the appeal. So these provisions were made applicable to Part 2 also, even though these provisions fall in Part 1. Now another amendment was brought into Section 9. So earlier what was happening, in arbitrations, people were filing Section 9 applications, filing interim measures, seeking interim measures before the court, even though there was an arbitration tribunal in place. So now this would delay the arbitration proceedings a lot. So now the Section 9 was amended and the legislature clarified that the court shall not entertain an application under Section 9 when there is a tribunal in place. So if there is an arbitral tribunal, you go to the arbitral tribunal, you will not be allowed to go to the court under Section 9 unless the relief which you are seeking, it is such which is not in the domain of the arbitrator. So this is what important amendment was introduced to Section 9. Now another amendment was introduced to Section 17, wherein the court held that arbitral tribunal shall have all the powers of the court. So earlier what was happening, the orders of the arbitral tribunal were not being treated as a decree of the court. There was some distinction between an order passed by the court and order passed by the tribunal. Now this Section 17, teeth were given to the orders of the arbitral tribunal and they were being treated as a decree of the court. So I think that was another very, very important amendment which was introduced to Section 17. And the most important amendment was introduction of a time limit for pronouncing an award. Now in the 2015 amendment, this amendment was brought in by Section 29A, wherein they said that a period of 12 months will be given for pronouncing an arbitral award or for making an arbitral award. Now this was a game changer because in 1 year, the whole arbitration will be decided. So that was actually very commendable by the 2015 amendment. Good move, and a pro-arbitration stance was taken. Another interesting stance was taken in the Section 34. Section 34 deals essentially with the challenge to the arbitral award in India. When there is any award which has been passed, it can be challenged under Section 34. Now the scope of interference by the court with an arbitral award was reduced, and the legislature clarified the meaning of public policy, and it also said that it will only be when the award is affected by fraud or corruption, and if it is in fundamental conflict with the fundamental policy of the Indian law, or if it is in conflict with the most basic notions of morality or justice. So this is what it said, that these are the few grounds on which you can challenge an arbitral award. Therefore, the scope was reduced to a great extent, so that the judiciary cannot interfere with arbitral awards on flimsy grounds or arbitrarily. One important move was that the ground of patent illegality was not made available for an award which was a foreign award. So if you are challenging a domestic award in the court of law, you can get it challenged or set aside on the ground that it is patently illegal. Whereas if it is a foreign award, then you cannot say that this is patently illegal and you cannot get it set aside. So patent illegal award, which is a foreign award, will not be set aside. So that was something very important question. Okay, so I just got a message that can we ask questions? Okay, so I'll just finish in the next 10 minutes and then probably we can take some questions. I'll just finish these amendments and then I'll be open to answering any questions that you may have. So the amendment of 2015, these were the major amendments which were brought in. Now coming to the controversy which was surrounding the 2015 amendments. The major controversy was regarding the applicability of the amendments, whether these amendments will be prospective in its application or it will also be applicable retrospectively. So one important amendment to 34 was that the court said that the legislature introduced that automatic stay will be done away with. I just mentioned about the automatic stay problem, that parties used to challenge an award and then they would get an automatic stay on the execution of the award. Now, under the 2015 amendment, 36(2) was brought in, which said that if you want to stay the execution of the award, you will have to move a separate application and some deposit will have to be made. After that deposit, you can get the award stayed. So this was a very, very good move and pro-arbitration stance again in favor of the decree holder so that he's not deprived of the fruits of the award. Now, the issue which came because of this amendment, because the amendments were to apply from 23rd October 2015, the controversy emerged that whether this amendment regarding the stay of the award, will it be applicable even to those applications which were filed prior to the amendment and are still pending today. So those 34 applications which were filed before the amendment and are still pending after the amendment. So whether the amendment will apply to those or not. Now it took Supreme Court 3 years to answer this controversy. In 2018, a very important landmark judgment came, which is the Board of Control for Cricket in India, Bcci versus Kochi Cricket Association. In this case, the court held that the provision of 36(2) is retrospective in nature, which means that even to pending 34 applications, the amendment will apply and there will be no automatic stay on those pending applications. You will have to file an application under 36(2). So basically 36(2) of the Arbitration Act was applied to pending 34 applications. This was the nutshell. Now another development was that in spite of this, Section 87 was brought in the legislature in the 2019 amendment, which is the second amendment after the 2015 amendment. And Section 87 said that all the provisions of the 2015 amendment are prospective. So in a way, this was contrary to what the judgment said in Bcci, because Bcci said 36(2) will be applicable retrospectively. But Section 87, which was introduced in 2019 amendment, it said that no, everything is prospective, nothing is retrospective in the 2015 amendment. Now this Section 87 was challenged in the case of Hindustan Construction Company versus Union of India in 2019. And Justice Nariman said that I'm striking down the insertion of Section 87 as the same is manifestly arbitrary. So this was a very interesting judgment. You should read it whenever you have the time. Now coming straight away to the 2019 amendment. But before that, I will just highlight two judgments which you can read whenever you have the time. These are on seat and venue, because seat and venue controversy has remained and emerged a lot of times. So there was a judgment of Hardy Exploration case, which said that if there is venue or place mentioned in an arbitration clause, then it can be treated as a seat only if there are additional factors which indicate that this venue or the place was supposed to be the seat of the arbitration. That is what they intended. But BGS Soma judgment came in 2019, which said that no, Hardy is incorrect. The venue or place, irrespective of specific mention of the seat, regardless of its designation as a seat, will be treated as a seat of arbitration. So if somebody has mentioned venue or place and there's no mention of the seat, then they will be treated as a seat of arbitration. So this is the law how it stands today. But Hardy and BGS Soma both are three-judge bench. They cannot overrule each other. So we will have to see what eventually happens in the future. Another interesting judgment which you all must read is Perkins Eastman Architects versus HSCC. This judgment was pronounced on 26 November 2019 by Justice Yuju Lalit and by Justice Indu Malhotra. And this judgment basically solves the most important controversy, which was the unilateral appointment of arbitrators. So earlier the position was that in a dispute between two parties, one party would retain the right to appoint an arbitrator. And obviously, you don't bite the hand that feeds you. So the arbitrator would not pass an award against that party who appointed it. And that's why it was leading to a lot of parties losing faith in arbitration in India. Therefore, this judgment of Perkins Eastman, it clarified that a person who has an interest in the outcome of the dispute must not appoint a sole arbitrator. So this was clarified that unilateral appointments will no more be considered. Thereafter, the amendment of 2019 which came, the whole purpose of the 2019 amendment was to institutionalize arbitration in India, because one of the major issues in India is that most of the arbitrations, 90% plus, they are ad hoc and they're not institutional. So a committee, a high power committee was formed, which was headed by Sri B.N. Sri Krishna, who was a retired Supreme Court judge. And the Sri Krishna committee, it gave recommendations that we should form Arbitration Council of India, which will promote and encourage institutional arbitration in India and grade the arbitral institutions and arbitrators in the country. So this will help in boosting the international arbitration culture and institutional arbitration in India. So because of this, 8th schedule was introduced in this of the amendment of 2019. 8th schedule basically said what will be the qualifications of an arbitrator. Now this was controversial because it added that the arbitrator must be an advocate under the Advocates Act of 1961, having 10 years of experience. Now this led to a lot of confusion, because this means that foreign arbitrators cannot be appointed as arbitrators. And due to this reason, amendment of 2021 was brought in, which is the third amendment to the 1996 Act and the most recent, the last. In this amendment, firstly, they omitted the Schedule 8, which is talking about the qualifications of an arbitrator. This was omitted. Now, the second key amendment which was brought in was amendment to Section 36. So like I told you, 36 is execution of the award. And earlier, the position was that you can only stay the operation of the award or the execution of the award if some deposit is being made by the losing party who's challenging the award. But this amendment of Section 36 in the amendment of 2021 said that there will be an unconditional stay on the execution if the contract or the award is induced by fraud or corruption. So I think this is a very regressive approach in the 2021 amendment, because now people will be challenging the arbitral awards and they'll be creating a ground of corruption and fraud, because they don't really want to pay the money, to deposit the money after losing. And therefore, they are going to take advantage of this amendment and they will say that the contract or the award was induced by fraud or corruption. So this is the long and short of the amendments and the history and evolution of everything that has happened in India till today. Now that 45 minutes are over, I think I'll be open to taking questions. And yeah, I think for 15 minutes we can take questions.
That's great, sir. So, thank you so much, sir, for enlightening our participants. Now, okay, there are questions coming. So I'll read out the questions for you, sir.
Yeah.
Okay. So the first question is from Aman. He says, I am Aman, a civil engineer and recent law graduate from IIT Kharagpur. Sir, I have two questions. First one is, what according to you construction industries and government organizations like NHAI should focus on, especially with respect to contract issues, as we have to deal with FIDIC contracts and other regulations? So to minimize the disputes, as in India, more than 70% of the ADR cases come from this industry. So, sir, first question. Sir, you may answer this first question, then I'll repeat the second one.
Okay, perfect. So his question is regarding NHI and such organizations. See, I think the most important issue, if you want to minimize the disputes in India, I will just put it shortly. See, PSUs are the biggest litigator in the country. They file most of the cases. Now, the problem is that every award is challenged and every dispute is raised by the PSUs. They feel that if they will not do so, then there will be a problem. There will be some vigilance inquiry. So they always challenge arbitral awards. Now, what we must understand and what the government must explain to these PSUs is that all these arbitral awards which are being pronounced, and even where you are losing, you need to stop challenging. It's a thumb rule that every arbitral award is challenged, whether it is a reasoned award or not. So if it's a reasoned award, you should not challenge it. That will reduce the burden to a great extent. Secondly, if somebody is entitled to some money, you assess the claims, and if there is some merit in it, you pay it. Don't invoke arbitration for the sake of invoking it. So this will actually reduce a huge pendency of cases. And I think this is the key problem in India, that PSUs are challenging every arbitral award and raising every arbitration clause in every matter that they are doing. So I think that's one of important thing which they can do to reduce the burden. Well, what is the other question?
So the second question is, there was a recent judgment on novation of contract and arbitration, where it was said that novation of contract will negate the arbitration proceedings, if any, which form the clause of the parent contract. So are there any frame or the parties are free to novate at any stage on ongoing proceedings?
See, innovation law is very clear that if it's a principal contract which has an arbitration clause and it got novated by a subsequent agreement which has no mention of the arbitration clause, then you cannot rely. And yeah, in most of the judgments, the courts have clarified that it should be clear that the contract stands novated, and the new agreement, the later date agreement, should specifically say that the previous agreement is repealed or it is not in operation anymore. In that case, yes, you cannot rely on the arbitration proceedings. You cannot invoke the arbitration clause of the previous agreement, the principal contract. But the time frame as such is not there. That you can object once the person is invoking the arbitration. The limitation period for invoking arbitration is 3 years from the cause of action. So that would be the time period. Otherwise, as such, there is no. But yes, this objection needs to be taken before the statement, by the time you are filing the statement of defense, and you cannot wait forever to take this objection.
So next question is from Viswajit D. He says, since ADR proceedings and verdict are confidential, how can a new advocate in profession learn the proceedings and art of cross-examination?
Okay, Vishwajit has asked a very interesting question. Vishwajit, what you can do is you can, of course, learn with advocates and law firms who are doing arbitration day and night, and you can see cross-examinations taking place on a daily basis, or you can probably intern with any arbitral institute where arbitrations are happening, like DIAC. So you can see conduct of arbitral proceedings. Interns are allowed, and as such, there is no issue. So I think these are few things you can do to learn, art of cross-examination in arbitration proceedings which are confidential, and you can see how it is being conducted.
So, sir, the next question is, thank you, sir, for your time. Then she says, the legislature has been very anti-arbitration with the 2020 amendment, while the judiciary has taken pro-arbitration stances throughout last year's judgment. My question is, what would be an outcome of this clash to the field of arbitration? What is the way forward for expanding the scope of arbitration in India?
See, you're right. The judiciary is doing a good job. And one recent amendment of 2021, which I told you, which you are also referring to, it is not anti-arbitration, but it is a regressive amendment where unconditional stay is being granted in execution in some cases. Now, the only way to go forward is that legislature as well as judiciary will have to go hand in hand. They will have to set a precedent that yes, India is an arbitration friendly jurisdiction. We will not be interfering with foreign awards. We will be deciding your disputes quickly. We will not set aside awards on flimsy grounds. And pro enforcement approach must be adopted so that investors gain the confidence of India, and the investors start investing in India. So because if investors will invest, only then the arbitration will flourish, because we'll have a lot of work, lot of foreign investments coming in different sectors, which will lead to disputes eventually. But arbitration mechanism should be robust, like judgments which are being pronounced should be positive, because one wrong step by one bad judgment of the court can take us 10 years back, and it takes years to probably rectify it. So I think yes, that's the way forward. That's how we should look at it.
Truly, sir. So, sir, next question is from Harith. He says, I wanted to know if the arbitrators or the arbitral tribunal is empowered to pass a permanent injunction as an award in order to restrict a negative covenant in an agreement.
See, the arbitrator has all the powers of the court, and negative covenants, if you're referring to Section 28, I think, of Contract Act. So they are per se invalid. There cannot be negative covenants. You can get an injunction from the court under first when the tribunal is not in place, and later on you can seek an injunction from the arbitral tribunal when it is in place under Section 17. But you need to check as to what is the nature of the relief you are seeking and whether arbitral tribunal can grant that or not.
Okay, sir. So the next question is from Manish. He says, sir, as you talked about amendments, what can be the further improvements which can be done in the Arbitration and Conciliation Act 96 to make arbitration more popular? And the second question is, sir, I want to learn more about arbitration from you. So how can I apply for internship under you?
So internships, you have to apply to the firm's email, and subject to availability, your applications will be considered because I'm working with a firm. And the other question, so far it is concerned, I think uh, we need to be really, if you want to make arbitration more popular and robust, you need to make it more expeditious, and we need to stick to timelines, and professionals need to become serious. We need to have full-time arbitration lawyers, full-time arbitrators, because nowadays what is happening is that people are first finishing the court, and arbitrator has become the stepchild. These lawyers, after they are tired and mentally and physically exhausted, they do arbitrations in the afternoon, and sometimes they are not able to do it properly. So I think we need a proper arbitration bar which will take up these issues and will eventually help in making arbitration more popular. That's the way forward, I think.
So next question is from Khushbu. She says she first thank you for this wonderful webinar. Then she says, I have a question about your career. I am a first generation lawyer, and there are a lot of questions which keep making me worry, like from where I should start, how can I start, how can I take more and more knowledge? How did you overcome all the negativity during your struggle?
So there was negativity I think there's negativity around everybody when they are struggling or when they are students. It's very normal and natural. Until fifth year, final year, I was not sure what I'm going to do. I did not know anything about arbitration, and I did not know what is my future going to look like. But let things take their natural course. Start working hard, believe in yourself, read judgments, stay updated with the law. The most important part is reading and writing. Start writing your research papers, find your interest, identify it. Fortunately, I was able to identify my interest only after I joined the office. Until my college, I was thinking I'm interested in criminal law, but eventually it turned out that I was interested in arbitration when I started working on arbitration. So get as much as exposure as you can get by doing internships. And once you identify your passion or what you are enjoying, you then stay focused and work only in that direction. Do not look left and right, just keep moving. But be a little patient. Rome was not built in a day, things take time. So things will eventually come to normal. And these are tough times. Don't look at these times as the deciding factor. You have a long career, a long way to go forward. So just be a little patient and work hard. That's all I can say.
Thank you so much, sir. Sir, next question is again from Vishwajit D. He says, how will artificial intelligence impact possibilities and business of independent practitioners or new entrepreneurs, not only in ADR but also in corporate law grossly in India in present and upcoming era?
Vishwajit is our brightest star here, who's asking good questions. Vishwajit, I think it's going to play a very important role in times to come. Future of justice is going to be online, like virtual hearings and what we are doing today. It's all virtual. It has made our life easier, and I see it as a development, and I think it is here to stay. So independent practitioners, business entrepreneurs, they're all going to rely a lot on artificial intelligence, and they will have to start investing in it because this is the future. And I think in the upcoming era, proceedings will take place on this also. And it should stay as per my mind. And that's why I think artificial intelligence has a very bright future. A lot of law firms are already using AI softwares, and they have a dedicated team of information technology to handle these issues. So yeah, I think it's going to impact it tremendously.
Okay, sir. Sir, next question is from Yash. He says, how will the principle of competence and separability are applied in reference to Section 11 of the Act? Whether the jurisdiction of the court under Section 11 extends to declaring as invalid the constitution of an arbitral tribunal purportedly under an arbitration agreement, especially where the tribunal has been constituted by an institution purportedly acting under the arbitration agreement.
I'll clarify this very briefly. Under Section 11, now the courts have very clearly said, there's an NN Global judgment which has recently come. You can read it, it will answer all your questions. But I'll tell you that Section 11 is only limited to seeing whether there is a valid arbitration clause. There is an existence of an arbitration clause between the parties, and that is it. Anything over and above that will be seen by the tribunal under Section 16, because tribunal decides the Section 16 issue, whether there's a proper jurisdiction of the tribunal or not. All of those issues, everything subsequent is to be seen by the tribunal under Section 16. So the court under Section 11 has very, very limited powers, only to see if there is an existence of an arbitration clause. That's it.
Okay, sir. So next question is from Bhavya. She says, what are the legal lacunae that make people frown upon India as seat of arbitration?
So legal lacunae, I'll tell you, the issue is that, like I told you, the institutional arbitrations are not there. Then judiciary is very slow, according to them. Whenever they go to the court, the matter gets stuck for a year. That is the major issue which these foreign investors have by having a seat of arbitration in India. So I think the most important thing is that we need to expedite, and we need to stop interfering with arbitrations, stop issuing anti-arbitration injunctions, stop resisting enforcement of foreign awards. And I think that will actually keep us in the good light and will take us much forward.
Thank you, sir. Sir, next question is from Tanya. And she says, sir, what are the initial steps that a student can take to learn more about the arbitration procedure? Also, can you please suggest some books or other reading material that would be helpful regarding the same?
So you can watch, Tanya, such lectures, and you can probably follow some people on LinkedIn who are following such updates, posting updates on arbitration. Then you can read some recent articles, read some judgments. Book, I would recommend you, Justice Indu Malhotra's book is very nice. You can read that. And there is for international arbitration, you can read Redfern and Hunter. That's very important, Bible of arbitration. So yeah, that's my suggestion to you.
Sir, next question is from Vaibhav. He says, sir, briefly, could you explain a tad more upon the patently illegal awards while you were explaining the domestic and foreign awards?
There was a question by Sarthak before that. He's asking about my book. So basically, Sarthak, people who are looking guidance in the career, the book that I have authored is On the Rise. I have covered the struggles of a lot of first generation lawyers as well as people from different fields. So if you need a mentor, you have 20 people I have shortlisted from different fields of law, senior advocate, judiciary toppers. Everybody has written advice for students. So the book is serving as a platform for people who are otherwise nervous to approach people and looking for guidance. So I think that book can help those people. Yeah, sorry, now you can come to Vaibhav's question.
Yes, sir. So next question from Vaibhav, and he says, Sir, briefly, could you explain a tad more about upon
Okay, I got his question. I got his question.
patently illegal awards? Yeah.
Yeah, I got his question. So basically, okay. So when you are challenging a foreign award, the ground of patent illegality is not available, which means that even if a foreign award is patently illegal, it will not be set aside by the court. The court cannot set aside on that ground, which means reduced scope of challenge in case of a foreign award. And in case of a domestic award, if it is patently illegal, it will be set aside. Now, what is patently illegal? Something that shocks the conscience of the court and it appears on the face of it that it is incorrect. So that is patent illegality, and that is the point which I was trying to prove. Yeah, now you can.
So, next question is from Mehreen. She says, could you walk us through how the provisions for the automatic stay in the 2021 amendment will cause delays in the enforcement of awards in future? Does
Yeah.
a party only have to bring an unsubstantiated claim of fraud or corruption and to trigger the stay? Will the courts conduct a prima facie review or do a full review? Does it take Indian courts a long time to consider a pending case, or are they quick to take an initial look at the case but take a long time to decide?
Hi, Marine. That's a very interesting question. So basically, what problem that I face and I think will happen in the 2021 amendment implementation. So one is that now there is a ground for unconditional stay, which is in fact in a way looking like automatic stay. It is not automatic stay per se, but it is taking us back to that era again. Because when I am an award holder in my favor, and if I am trying to execute it, but Marine, for instance, you challenge the award and you raise the allegation that the award was pronounced on the edifice of fraud or corruption was involved or the contract was on the edifice pyramided on fraud, then you can seek a unconditional stay without any deposit or without any conditions. My award will be stayed. Now the court will have to examine whether these allegations of fraud or corruption are actually there or not. You will have to show if the court feels that there are prima facie findings of fraud and corruption and court is convinced, then the review will be there and the court will definitely stay the award because it cannot be a very detailed or very full complete review because that is for the final decision in 34. But until the 34 is pending, this will serve as a prima facie view that the court will take, and depending on that, if the court is convinced that yes, the award was obtained by fraud or corruption, etc., then the court will definitely stay it unconditionally. Now, the other thing is that yes, it takes a lot of time to consider a pending case in India. It's not something which happens in months. It takes years, probably 2 years or 3 years it may take on a regular basis. And yeah,
Yes,
so
sir.
and the stay is granted in a short time, which you said. Initial look, which would mean a hearing which can last on for 1 hour or 2 hours, depending on the availability of the court. So sometimes 1 to 2 hearings can take place to decide this application of stay, because stay application is separate. It is under section 36(2). So to decide this application, court would not take that much time.
Thank you, sir. So next question is from Ipsita, and she says, "Sir, I am a second year law student and not much sure about exactly which legal field I can do good at, or I am interested in. So what should I do to recognize the appropriate field of law for me? And is it okay not to be sure about the field even after coming to second year or the first year, or I'm late?" She says.
Okay, so that's also an interesting question, but you don't have to worry. Second year is never late. It's second year is for enjoying, for relaxing, for understanding the basics, not for being so professional and thinking so much about taking stress about this. You need to just stay focused on the subjects which are being taught. I did not know until fifth year what I have to do. So you are still having 3 more years in comparison to me. And what you need to do is you need to intern at different kind of offices if you're not able to identify your interest. Work with a criminal lawyer, work with a civil lawyer, work with a corporate law firm, work with an arbitration lawyer, IPR lawyer. And this way you'll be able to understand that, yes, this is something which is of my interest. The moment you have that feeling, you start interning and writing only on that subject and focus on that subject as your career. Rest, don't worry, you have a long time to go, so don't worry much.
So, sir, next question is again from Vishwajit, and he said, sir, can you put some light on basic difference between corporate law and commercial law?
So, okay, Vishwajit, all questions you can ask me personally. You have my contact details. But basic differences for commercial law, these corporate law is somebody who's pursuing in-house. Most of the time you are in the firm, you are reviewing documents, you are making com view of documents, examining documents, due diligence, etc. This is all corporate law. And whereas when you do go in the court, and commercial law is when you, like the lawyer that I am, disputes between the parties, that would fall in the ambit of commercial law, civil matters, all of that would form in the commercial law. So I think our time is up, but we can take two more questions probably.
Okay, sir. So,
Yeah.
next question is from Manish. He says, can you suggest some good firms or good advocates for internship in arbitration?
No, 1 second. I'll take the question first. Ujwal asked me the name of the judgment. Ujwal, I said it's NN Global. It's a judgment by Justice Indu Malhotra. Probably you can check it, and I am going to share it shortly on my LinkedIn. You can take it from there, or you can ask me. Then Manish asked me a question. Manish, good firms, good advocates for internships in arbitration. Though it's not a related question to the webinar, but I will tell you. Uh, Good advocates in good firms, you can apply at Kachwaha and Partners. It's an arbitration firm. You can apply at PSL. You can apply at AK Singh and Company. You can apply at all these tier one firms. They have a good dispute team, SAM, CAM, Trilegal. So yeah, these are some firms which I think you can consider applying. Now, Marine asked a detailed question. Could you elaborate on the difference between the terms? Okay, unconditional stay and automatic stay. So, Marine, automatic stay under the 1996 Act was that when I am filing a challenge to the award, I'm not filing any separate application for staying the award. The award would get automatically stayed, and that nobody can enforce it merely by filing a Section 34, which is a challenge application. Now, unconditional stay is different. Unconditional stay is in a Section 36(2), when you are filing an application for staying the award, because it's a separate application, then you are seeking an unconditional stay on the award without any condition of deposit of the arbitral award. Because the general norm is that the stay is always conditional. You have to deposit 50 to 75%, and in some cases 100% of the award amount. So that is the difference. Now, Ria has asked a question, would an application on 34 survive even though the ground mentioned subsections were not challenged during the arbitral proceeding? Ria, it depends on what kind of objection it is. Suppose if it is an objection regarding fraud or corruption or something which has come subsequently in your knowledge, that the arbitrator was not independent, etc. Then of course you can take those grounds in 34 too. There are one or two judgments that even at the stage of 34, you can file an additional affidavit. There's a judgment by Justice Nariman, but normally it is not permissible. The grounds which you have taken in arbitration, you have to stick to those grounds. That's the law, unless you are able to show why you were stopped from taking those objections at this stage of arbitration. Okay, do we have any other question?
Okay. There's one last question from Khushbu, I guess.
Okay, Khushbu has asked a question. Can you tell us how we can do internship under you? Thank you, Khushbu. You can apply to our firm's email ID. It's Advani and Company. You can see the website. There is an email ID of the Delhi office. You can apply there. Subject to availability, they'll consider your application and you will get an application. Thank you very much. Thank you, Vishwajit, Tanya, Ria, Khushbu, all of you for being so active and for a good question. Thank you, Marine. And if anybody has any questions which I have not been able to answer, you may ask me on my LinkedIn. Due to paucity of time, we can't take all questions. So thank you, everyone.
Thank you so much, sir, for accepting our invitation and coming to this wonderful webinar session. Thank you, sir. We'll be hosting more webinars in the future with Tariq, sir. Thank you so much, sir, for accepting our invitation.
Thank you, everyone. Thank you for your time.
Thank you, sir.